this will be your opposition. You have a full 55 minutes. Again, we'll give you the 5-minute warning, the 1-minute warning, and when to stop. Okay? We'll have you argue uninterrupted. Thank you. And if you're not speaking, please mute yourselves. All right. And Helen, you can log in his start time.
Okay.
Thank you.
Thank you.
All right, Mr. Page, I'm ready.
We've already dealt with this before. This was at the hearing that went on for 2 hours as well before you got the report from Shelley Cooley. So we're just keep grinding over the same ground time and time again. Mr. Norcutt Mr. Counsel starts off by arguing that starts out with the relocation case. The relocation case is res judicata. He doesn't keep trying to make oral motions for reconsideration. It's done. She was allowed to relocate. The GoFundMe page that he pops up as Exhibit 10 is undated. It was done probably well before Ms. Norcutt ever relocated, but we can't tell because it's undated. The letter from the football coach is hearsay. It's not entitled to any weight. We don't even know if he wrote it. We know from talking to Ms. Cooley, though, that Gage isn't even interested in football right now. He'd rather focus on art. But Mr. Counsel is apparently too hard-headed to figure that out. He keeps talking about football, football, football. Kid doesn't care about football right now. Let it go. Little wonder his son wants to spend as little time as possible with him. Mr. Counsel claims that Gage is doing worse in school. That is contradicted by the investigation and conclusions of Ms. Cooley. She did a thorough job in interviewing Gage and looking at the underlying records. Her conclusion was that Gage is actually doing better now than he was doing in Las Vegas. And he's doing better now in Washington than when he first got to Washington. Mr. Norcutt, Mr. Counsel can't ignore that out of existence. Mr. Counsel says that Gage has athletic abilities. We have seen zero evidence, a scintilla of evidence, that Gage is anything exceptional as it relates to athletic abilities. Zero, zilch, nothing. Mr. Counsel saying that my kid is really, really talented because I say he's really, really talented is circular reasoning that fails to meet any cogent level of legal proof. Every parent wants to think that their kid is special and unique and has some exceptional abilities, whether it's football, basketball, playing chess, something. There is zero evidence to support the contention from Mr. Counsel that Gage is slaughtered for Bishop Gorman. Again, Mr. Counsel saying it is because I say it is circular reasoning. It fails to meet any level of legal proof. Mr. Counsel says that Gage attends a private school in Seattle, Washington, and that somehow Ms. Norcutt contradicts herself by saying that he was opposed to private school in Las Vegas but is in favor of private school in Seattle. Mr. Counsel should be more involved in his child's life. The school Gage attends is not a private school. It's a public school. If you're going to make factual allegations, please make sure they're not 180 degrees incorrect. Mr. Counsel says that he has good character. Character witness is inadmissible as a matter of law unless it's an element of defense or if one opens the door by saying they have bad character. Hasn't occurred yet in this case. Mr. Counsel says that 99.9% of the students at Bishop Gorman get a full ride to whatever specialty they have in college. That on its face is farcical. he provides no evidence that any percentage of any student at Bishop Gorman goes on to college and gets a quote-unquote full ride. I would regard that as an intentional material misrepresentation to the court as to Bishop Gorman. What is most important for children is stability. Gage is stable. He likes where he's at. He's doing better in school. His behavior is better. His grades are better. He is involved in a program called Unleash the Brilliance. He likes it there. That's what's more important. The chaos in his life came from being in Las Vegas. Now that he's out of Las Vegas, the chaos, i.e. Mr. Counsel, is out of his life, and he's slowly but surely starting to do better. That's what's most important. As to the emails that he sets up there about Ms. Norcutt using profanity and something about her bed, he's used that email ad nauseum now. He used it at the last hearing where we went over the same ground again before Ms. Cooley gave her report. I believe he's used it at some point in trial now. It's an email from 2017, 3 years ago. Let it go, Mr. Counsel. Mr. Counsel complains about the tardies that Gage has. The tardies are from when Gage is going from class to class. It's part of his maturing process. He had bad behavior in Las Vegas. His behavior is getting better in Washington. There is zero evidence that he would not have tardies in going from class to class in Las Vegas. So his attack is entitled to little weight. When you talk about bad environment, or he talks about bad environment, the bad environment in Las Vegas is what's led to the bad behavior in Las Vegas. Now that he's out of a toxic environment that was fostered by Mr. Counsel, he's doing better. As the poison that Mr. Counsel fed into him is slowly being dissipated, he is now doing better. He's in a much more positive environment, and consequently, he's starting to become more self-aware and is starting to do better. It is one of the things where Ms. Cooley indicated that even though Gage's grades haven't been real great and his behavior could be better at times, she thought that he was mature enough and level-headed enough to have an opinion and to have that opinion to give him some weight. And Gage's opinion was that he really doesn't want to see his father too much. He might see him at spring break and 2 weeks in the summer, but that's about it. That is the natural consequence of Gage being aware of the toxic environment that Mr. Counsel provides and the nurturing and positive environment that he finds himself in Seattle with his mom, with his older brother, and with the family members that he has in Seattle. It is uncontroverted that Ms. Cooley found that Gage's grades are better than they were before and are continuing on an upward trend, and that his behavior is better and is continuing an upward trend. That is not to say that his grades couldn't be better. It's not to say that his behavior could be better. But the fact of the matter is the person who doesn't have a dog in the fight, the person who is only looking out for what is best for Gage, in addition to this court, is that he is on an upward trend in Seattle, in Auburn, Washington. In Las Vegas, he was on a downward trend. He was doing horribly in school, and the school behavior, the school grades were getting worse in Las Vegas. It would make no sense to put Gage back into that environment to see him further flail and flounder in the toxic environment provided by Mr. Counsel. Yes, Gage has some missing assignments. It's still better than it was before. we do know as far as the toxic environment is concerned is that Dad, according to Ms. Cooley, engaged in alienating behavior toward Gage regarding his mom. Your mom doesn't love you. Good job, Dad. Good job. What kind of sick parent says something like that to their kid? Gage was able to contact his mom about once every 2 weeks when he was in Las Vegas. Again, good job, Dad. What kind of parent does that to their child? Mr. Counsel appears to believe that this is all about him. It's not all about him. It's about what is best for the child. In what environment is the child going to do better? A child is not going to do better in an environment where they're failing here in Las Vegas, where the father's telling the child, your mom doesn't love you and doesn't allow contact. Ms. Cooley even had to fight with Dad to get Gage there for the interview. Dad tried to put up various sorts of roadblocks. Oh, I'm not sure if it's safe for COVID. Gage is in 8th grade. His chances of getting a negative impact from COVID are less than negligible. It was delayed for the sake of delay because he knew inside what Gage was going to say about him because he couldn't cover his behaviors. And Gage also complained to the guardian ad litem, Ms. Cooley, that Mr. Counsel recorded his phone calls. He couldn't have any privacy. So Ms. Counsel, or Ms. Cooley and myself were both on point in making sure that there was an in-person meeting and not a telephone meeting so Dad couldn't interfere with that process. It's appalling behavior. Mr. Counsel claims that Gage is depressed and is acting out, plays video games. He provides no evidence of that. Maybe Gage is depressed with him because he doesn't want to be there because the environment in which Mr. Counsel provides is so negative that he can't wait to flee it. He complains about whether he has an emergency contact. Really? He's still the father. He still has access to all of the school records. He still has access to all of the teachers. So he's obviously listed as the father. Yet he complains that he is not listed as an emergency contact. Well, if there's going to be an emergency contact, that emergency contact probably should be in Seattle or Auburn where the child is. So if someone has to go to an urgent care facility or a hospital or an emergency room to make sure that treatment can be given, that they're aware of that. Also, since Mr. Counsel and Ms. Norcutt do not have a good relationship, there may be delays in being able to get a hold of each other. So it would be better that somebody else other than Mr. Counsel be listed as the emergency contact. Mr. Counsel says that he would fly there and that I'm in contempt and Ms. Norcutt is in contempt because of spring break. He didn't say that he was going to fly there. I think at best he said it might be a welfare check. But in any event, travel was not recommended during the height of COVID. So it was concluded that it would be reasonable that Gage not fly down to Las Vegas for spring break. What Mr. Counsel omits mentioning to Your Honor is that he was offered and received an extra week over summer to make up for him losing out for spring break. That was the reasonable, rational, correct thing to do as it relates to COVID, and we're still trying to figure out what is going on in the world. It happens a lot in family court cases, and this is the one that was the solution that was fostered to make sure that he still saw Gage for the amount of time ordered by this court, yet took into consideration the unknowns regarding COVID at that particular time. So he received his compensatory time, and he has nothing to complain about. He also says that Gage misses football. Did he not listen to Ms. Cooley? Gage isn't interested in football right now. How much clearer does he need to make it? He's more interested in art right now. That's why he's getting A in that class. He's probably also being positively influenced by his brother, who is an art student, as to why he is interested in class and is doing well in the class, and again, does not want to do football. Rather than trying to beat us square peg into a round hole, Mr. Council might do better by supporting what his kids' interests are. Football's Mr. Council's interest. It's not Gage's interest. That's the narcissism that bleeds out in this case, that despite him saying that it's not about him, it's really about him, and he likes football, so therefore he wants Gage to like football. Gage is his own individual person. He's going to like what he likes. It may not be like what his dad likes. It may not be what his mom likes. But he is a person, and he's going to make his own choices in that regard. Those choices should be respected, which Mr. Council fails and refuses to do so. This motion was filed as an emergency. There is no emergency in this case. There's not adequate cause for there to anything else to happen. We have a evidentiary hearing which has been going on here for almost a year regarding his overall request for change of custody and return to Las Vegas. Mr. Council has failed to identify any exigent circumstances which would require an emergency return of Gage to Las Vegas. There is no exigent circumstance that would require upsetting his schedule, interfering with the friendships that he has made, interfering with the sibling relationship that he has with Gavin, interfering with the school and the classes which he's become familiar and comfortable. There's no reason to interfere with the Release the Brilliance program, which seems to be very positively impacting Gage. More importantly, Mr. Council fails to provide any evidence, any argument that Gage's best interest would be enhanced by returning to Vegas. Mr. Council saying that it is because they say it is, again, for probably the third time, is circular reasoning that fails to meet any level of legal proof. Mr. Council saying, I wouldn't let him be tardy to class. Well, unless he's going to walk him from class to class, guess what? Gage may be tardy. That's a reality as part of the maturing process of this young man. He gives no evidence that Gage would be in a better school. He provides no comparison between the schools in Las Vegas and the school Gage is currently attending. He provides no evidence that the Bishop Gorman, which Gage can't get into, is any better. He can't provide any evidence that Faith Lutheran, which he can't get into, is any better. He can't provide any evidence that a public school that's zoned for the area for which Mr. Council lives is any better than the school in which Gage lives. There is abundant evidence that it would be a detriment for Gage to go to Las Vegas on an emergency basis because Mr. Council doesn't have telephone contact once every 2 weeks. Mom has testified to, as Ms. Cooley found it, Mom set a timer, and that's when Mr. Council was supposed to call, and that Gage reported his dad never called, even though the communications were freely available to him. He never availed himself of it, and instead tried to create conflict for his own selfish, narcissistic reasons. There was also the alienation which Ms. Cooley indicated was going on. Your mom doesn't love you. How is that going to be an enhancement of the child's best interest under Ellison versus Carucci under an emergency basis during the same evidentiary hearing in which he's trying to change custody, that there's going to be an enhancement of the child's welfare? There is none. In summary, there are no exigent circumstances. There is no adequate cause. There is no material change in Gage's circumstances warranting a change of custody, and there is certainly no enhancement of Gage's best interest by attempting to change custody in the middle of an evidentiary hearing on a non-emergency basis. With that, I have nothing further. Thank you.
All right, thank you very much, Mr. Page. I would permit 10 minutes. So Helen, if you can type in his start time and give him his 5-minute and actually with the 10 minutes he should have a 1-minute warning and then he would stop.
How much time did I take? I didn't count.
10:04 to 10:24, so that's 20 minutes. I can have Helen type that in the box. Motion, Mr. Page.
For attorney's fees, I've spent probably more time on a trial on a simple motion hearing in this case, all because of Mr. Counsel.
Well, if you
actually, note here, the report by Ms. Cooley last, whatever day it was basically an hour beatdown of Mr. Counsel. You're not going to see many guardian ad litem reports as negative toward one party as you saw from Ms. Cooley to Mr. Counsel. And that's not only with this report, that's with the first report. Effectively, her report ripped into Mr. Counsel from start to finish. And we're here expending hours of time when he knew that was going to be the outcome of the report because he tried to prevent Gage from being interviewed by Ms. Cooley. It is a waste of your time, Your Honor, a waste of counsel's time, and a waste of Ms. Norcutt's time. He adequately compensated for going through this for basically 5 hours now over an emergency motion that's really, at the end of the day, a non-emergency, and actually was, like I said, a beatdown of Mr. Counsel for an hour. I guess today's Friday. I guess it was Wednesday. I'm somewhat frustrated, and I think that comes through a little bit. I'm sorry.
Okay, so since you have extra time, and if you're not going to use all of the time, and Mr. Counsel here is going to get the last rebuttal, then I think I'd like to ask just a few questions, Mr. Page, on your time. So we'll keep adding to his time, Helen.
Okay.
Now, I believe both Murphy versus Murphy and Ellis versus Carucci did involve a child who was failing school. It's substantial change of circumstances affecting not the welfare of the child, not the parent. So the welfare of the child.
Senator, now.
In terms of if there was a compelling case for schooling, the competing factors, the court is weighing in upon is obviously the sibling relationship, best interest of the child factors still do apply, the sibling relationship, the stability of the child, and with the relocation effects, the whole purpose was to improve the quality and life of the child. So basically my question is, I don't think that, school is a major factor. But if, is it in the best interest of the child just to, weigh our hat in on just the school issue? I'm not going to disagree. Him and Gavin are pretty close. And also the level of conflict and obviously their ability to communicate and co-parent. But the ultimate question is here, should the court, are we following Ellis versus Carucci because or Murphy versus Murphy? I think those involve kids with schooling problems. Did Ellis shed some light on beyond just the school, the failing grades?
Well, if we're going to take a look at what is, whether there's an enhancement of the child's best interest, I think we still have to look at what the factors are under 125C.0035, and because one has to cite one of those factors if one's going to change custody, or make an award of something other than joint physical custody, So I don't think that any of the factors, as we've gone through them with our argument in Ms. Curley's presentation, apply. There's not a shred of evidence that a child is going to do better in Las Vegas versus Seattle, particularly when you have to give Ms. Curley's report weight, which is that Gage is doing better than he was before. He's not great, no one's going to say that he is, but he's certainly doing better than he was before.
Okay, so by comparison, prior to the move, he was also struggling with school in Las Vegas, and then he was
awful.
What do you recall?
Well, I might have non-shine on this because she lived it, but literally he was a straight-up student.
Okay, sure. Maybe mom wants to, the parents know their child better than anybody. So if mom wants to say something about it,
take off your mute.
I've submitted his grades.
That would be your rebuttal, your 10-minute rebuttal.
Okay. So, Goldie, you had, what was Gage doing academically in Las Vegas? Was he being better?
Yes, and I sent you an email yesterday with his grade average. His GPA in 5th grade was 0.88, which is below an F. In 5th grade, the completion of 6th grade, his GPA was, hang on. Do you have that email, Fred?
I'll see if I can find it. I have other things to do here in just a second.
Anyway, it was a D plus, almost a C. It was a 1.24 something, almost a D. Then to finish the 7th grade, it was a 1.4 something. I just talked to the school yesterday and I sent all the information to Fred. It was almost a C plus average. So he had to restart his 6th grade year, go into middle school, to make it to class, learn new behavior coping mechanisms, and also get plugged into a good counseling group so that he could learn new behaviors. And then in the other part of 6th grade, his dean at that time recommended him to unleash the brilliance because he has great leadership qualities. They can see that, but he has self-control issues. He has been subjected to a very unfortunate situation between a very ugly divorce, very ugly co-parenting, very ugly custody battle, and he is starting to have a voice and starting to learn to have a voice. And so the dean at that time is now the principal at Cascade. So last year, in 7th grade, he participated in this program all year, and they practice Love and Logic's parenting. In fact, Gage and I, which I spoke to in the last hearing, we participated.
You guys hearsay. No documentation. No documentation.
This is still a session, Mr. Counsel. You can mute yourself. You get the last word here. You get the last 10 minutes. And now when we get to his 55 minutes, so Mom has and her counsel have every right to use their remaining time. I'm sorry, Mom. So, love and logics, what is that?
It's the programs of the different types of parenting. So you have consulting parenting, you have the helicopter parent, which is the parent that, their kids can do no wrong, very codependent. You have the demonstrated parent as far as the controlling parent, the domination. So there's 5 different types of parenting. And Gage and I, which will be on the evidentiary hearing, because I do have evidence, I have photos and a videotape of Gage and I participating in the program together. But we're not trying the evidentiary hearing. And I would like to correct this. This has been going on now since January 21st of 2019, Your Honor. This case has been in limbo for that long. And not only myself, and at that time I had Kurt Smith as my attorney. Attorney Page came on board July of 2019. He has done his due diligence. He has been amazing with patience, with the situation, with the emails, and doing just the constant, just like last night at 11:30 at night, I get an email that states that Mr. Counsel, father, has submitted evidence for an old GoFundMe account that it's completely irrelevant. I mean, I'm just scared. What breaks my heart the most is the fact that when Miss Sherry Clinton, the guardian at Whiteham, stated the other day that from his own father's mouth, he has told Gage that I don't love him. Then I'm sure there's lots more. No father or brother should ever say that to a parent or to a child. And he has berated me. He even made comments that said I was hiding last hearing. He has made horrible comments on record. Even, I don't even know. I don't even have words to say that no child should be subjected to that, and that is textbook.
That brings up how he had to find you at your sister's house. Do you want to give the context for that?
Sure. He did talk to Gage. Someone in our apartment community, in our building, we live like in a 5-story building, had the COVID. So we went to stay at my sister's, who lives in a 4,000 square foot house. And she has an apartment in the basement. We went and stayed there at her place. Alex did know where we were at. Gage did talk to him during that time, and he told him repeatedly that we were at his Aunt Angie's. And Alex has Angie's address because it's in the emergency contact. He just showed it. He has the Angie's address right there, and he just put it on the screen. Angie is the emergency contact. He could have easily sent the Winton authorities there to check on us, but he didn't because he was just trying to make a case. And furthermore, for the record, Your Honor, not one time has he ever offered to come visit Gage in Washington, nor has he ever executed any 3-day weekend in the course of the last year and a half since he followed this order, the original order. Every time there's a 3-day weekend, I put in our family wizard. Would you like to send for your son? Our son? And he says the same thing. He refers to Gage as his son constantly. My son. My son. I never refer to Gage as my son. If I'm in his presence, it's our son, because it is our son. He should never say, and if he's saying that in front of the court, what does he say to Gage? He's referring to Gage as my son. You're my son. No, he's our son.
So you tried to encourage the 3-day weekend. Has Gage ever said anything if my dad came here, what they would do or what activities he'd like to do?
I I put in our family wizard. Come up. There's a hotel down the street. You can have Gage for any weekend that you want. When I did go off the radar, which we discussed with Kurt Smith, in the first hearing, Mr. Counsel, father, did not sign the order he agreed to. He did not sign up for our family wizard. He had my address because I did a change of address. He knew exactly where we were at. He went off the grid. He didn't pay for child support. The $100 that he was ordered, which he perjured himself about that because we all know he was working. He lied during the evidentiary hearing. We have documentation. It doesn't matter. I could care less about the child support. The point is he's tried to fabricate a case that is not true. The minute he knew in January where Gage was at, allegedly, legally, and signed up for our family wizard, if I did not know where my kid was at, I would have been on the first plane to Washington that next day seeing my kid. He didn't. He waited. He waited until I had to send Gage down for spring break. And the 3-day weekend's the same thing. The minute I was on our family wizard, I put right in there, this 3-day weekend's coming up. Would you like to come up and see your son, or would you like to send for him? He didn't. But he claims that I alienated him for 8 months, which is not true. Again, he had my forwarding address, and I have documentation about that. And he had Kurt Smith's contact information. He knew where I was at. He chose not to participate because he didn't want to anymore. And then once he started having to pay child support, I got my first child support check for $52 the middle of December of 2018 for $52. He turned around and spent $5,000 and hired his attorney and filed a motion to have Gage return sick, claiming alienation. And we just heard from the guardian ad litem who's doing the alienating, not I. I've never done it. I set a timer. I encourage the relationship. There is nothing more than I want, but I don't receive the same respect when he is at his dad's, and it's all documented. Again, we're not trying the evidentiary hearing. This is an emergency order, and I would like to speak really quickly to the wedding. Yeah. Really quickly?
Yeah.
Okay, so Alex brought up in the last hearing that Gage came home with ringworm. He put it in the court docs or in his exhibits and everything, okay? He waited 3 weeks to take him to the doctor, okay? The child returned to Washington with ringworm and no medicine. He was at his dad's 9 weeks. 9 weeks. I already had a doctor's appointment scheduled for him the minute I picked him up from the airport for a COVID test and for his well check because he's going back to school. He turned 14 on Tuesday. He needed his well check. I need to make sure he didn't have any immunizations that were due before he returned to school. And he came home with the same ringworm, no medicine. Now I had to tell my oldest son he has ringworm, and they are all staying in a cabin together. And he's like, you can't send him here to sleep with everyone in a cabin with ringworm and expose everyone. And with the COVID the way it was, he's like, we're limited on attendance anyway. And as a family, all three of my sons and I all agreed that we were going to celebrate all of the birthdays, Thanksgiving, and Christmas in November. He's flying here. And so that's why they chose not to go. And it was a collective agreement. And I did. I popped in for a wedding and I came right back. But I want to tell you that the ringworm's gone. 1 week from the topical ointment that I picked up on that Tuesday that he came home, Wednesday, I sent Mr. Page a photo of it. It's gone. It's gone. And so how is it that it can be cleared week, and it took 3 weeks for Dad to take him to the doctor. And that's what I'm saying. I can't do anything right. I mean, he still uses an email that's, and by the way, Attorney Page, that email is not from 2017. That's from 2016. And we've already clarified that I didn't even have access to that email, or I didn't even write that email. I mean, we already cleared that up. He has to grasp at every little thing in order to form a case. Like I said, it's a desperation of a GoPro, or not GoPro, but yeah, GoFundMe. I mean, I just don't understand. It's just...
And there's one more area I wanted to ask you about, and I'll turn it back over to Mr. Page for the remaining time. The emergency contact listing for 6th, 7th, and 8th grades. Did you list that as emergency contact?
I don't, and this is, I'm sure I didn't on 6th grade, but I've called and corrected it. It's actually, Dad, we function on a thing called Skyward, right? It's called Skyward, an app. You can see your child's progress every day. Dad himself could go in and add himself to the contact list. He's made examples, he has exhibits of how accessible he is to Skyward. That's where he's got all the documentation. He could go in and add himself. He has full accessibility to anything with Gage. But, of course, he wouldn't want to do that because then that would not be, that would not look in, it would look poorly on me. I want to touch base, too. I just sent
Did Dad ever complain to you? He put me down as an emergency contact, and did you respond?
I don't remember, I'm sorry. But if he had Skyward, there's no reason to complain. He just does it himself. He can add it. They have all of this information.
You can do that by yourself? Yeah.
Yes. Yeah, he can. Also, Gage's tardies, if you look at his report card, those are not his he's not absent. If you look at his final report card and all of his tardies, the tardies are only from class to class. And it's not like he's tardy 15 minutes. He's tardy 1 or 2 minutes, and it is a maturity thing. Most middle schoolers that have struggled historically in school struggle to make it to class in a timely manner. And Dad even said he's a grown man and he missed an entire court date. They don't have a disciplinary hearing. He wrote down the wrong day. He's a grown man. I mean, cut it himself.
He was scrolling through okay, I added one more question, and that'll be done, Mr. Page. He was scrolling through behavior incidents. A kid would push him or knock his things off his table, and he would push him back. Somebody dared him to slap another kid, so he slapped the kid. Talking back or talking out in class or shushing a kid after the kid already went quiet. Do you see this as problematic in terms of, has he ever gone through counseling or therapy, actual treatment, counseling or therapy, since you moved to Seattle to address the behavior?
That's what the Unleashed Your Brilliance is for, is that they counsel and work with children that are formative and that they can be corrected. They work with all the schools in King County. It's a huge program. Gage's behavior
to address, they notify you every time, and Dad said he didn't notify him a single time every time there was a RPC or detention or something. Explain from your end.
Had access to Skyward every time Gage gets was in a conflict, and
It pops
again,
It pops up. Your child got in trouble today?
You have to look at it. It's accessible every day. I mean, I have it on my phone, I have it on my tablet, and you can have it anywhere.
out about these behaviors?
I practice the consultative parenting, which is what the Love and Logics is like, and we talk about his choices and his behaviors and his triggers and his decisions to make better choices. I give him consequences: no phone, no Xbox. Sometimes we do it with allowance. He does chores and I give him money. Sometimes I have to take the money back, or he has to put it in a jar. There's all kinds of things that I have implemented, and like I said, this is all the guidance of the Love and Logics program that I have been able to adapt since I've been to Washington. It's been very, very helpful. Gage's behavior since, Judge Moss, since he was a baby, has always been defiant. They even thought at one point he was on the spectrum of something. For preschool, there is not a school in Nevada that he was not kicked out of. And we're talking, and again, it's part of my exhibits, he has a full history of poor behavior, awful behavior in Nevada. And it wasn't just Nevada. We lived in Nevada when Gage was 4, and even in Indiana, he would just take off and run out of the school. Just things that, as a parent, I've had to be stretched from. I just had to learn to parent differently, and you can't be a dictator to him. You have to understand that his mindset and his behaviors are different than a common person or a common child that has not had any kind of trauma. And it has been trauma. He has seen a lot. He's witnessed the domestic violence between his brother and his father. He's witnessed the domestic violence between his father and I. It's been, and he spoke to that in all of the interviews. He spoke about it. It's been a rough road, and if he stays on his track, I think this is 8th grade, this is more mental, and we will see him turn around. Just like he said to the guardian ad litem, he was 13 before he could learn to ride a bike. That's really a gross motor skill that Gavin learned to ride a bike at 2. My oldest son, 2. He's delayed on a lot of areas, but if I didn't have to pay the tuition fees and being sewn up in the court system, I could afford a lot more secular help outside to get Gage some of the more, I hate to say it, but if father would actually pay his child support, as normal as it is, I could probably get Gage on some other programs outside of it. He even told the guardian ad litem, I want to focus on my behavior and my grades before I do anything else. And that's monumental. That's a maturity thing right there. Most kids would be like, I don't really care, I'll just do whatever. And that's not how he is.
Before we go, also, your daily routine with this virtual schooling in Seattle, what is the daily routine?
So school started Wednesday, and I've got his schedule right here. So at 9:35, he's logging in, and it's art, and that goes till 10:55. And then he has science from 11:35 to 10:50.
12:50, maybe?
Yeah, 12:50. Then he has math. Sorry.
Oh, it doesn't have to be that specific. I just want to know, does he work independently? Does you have to hover over him? And when does school end?
Math starts at 1:25 to 3:10.
Mm-hmm.
We're doing 3 classes, the first quarter, and then the second quarter is the remainder of the classes unless they get to go back to school. We went and did the drive-thru yesterday and picked up all of his books, and all the staff was out, reading the kids. The principal handed in all of this stuff, and the principal was doing when he first started to Vegas, or when he first came from Vegas. And he would personally, in fact, I want to ask him if he can testify in the evidentiary hearing, because he was walked right beside Gage in his journey. And yesterday, mask it off, he stuck his head in and he gave patting him on the chest, he goes, "How you doing?" I mean, Gage even told the guardian at Lyman, they care. They care, they're there, they show up every day for the kids. And that's something he never had in Vegas. He was just pegged as a horrible kid, and he couldn't cut a break. And that was from kindergarten on. And really from preschool on, even in Vegas. Like I said, we got there when he was 4, and it just was a...
So it's not a struggle for he knows how to log on at his age, at 14 now. He knows how to log on. Does he get fidgety? Does he have focus problems? Does he throw his pencil? Gets frustrated? He likes it? He likes now watching the online school?
Well, he would like to go back to school, but he's doing, they just started Wednesday, so, I mean, today's just Friday. So, yeah, and Gavin's, huh?
Oh, and so far he's made it through the first 2 days?
Absolutely. And he knows that, he has to do well. I mean, it's unacceptable for me. I mean, I tell him all the time, and he'll tell most people, he goes, "My mom's famous quote is that I'm better than that." So, and he gets that a lot. I'm like, "Oh, you're better than that. Like, let's just do well in school." You know, if he has poor behavior at home or at school, I always tell him, I'm like, "Why would you do that? Because you're better than that. You're a better human than that." So, I call him all the time my shooting star, and I tell you, he'll be something someday. He's come a long way.
Thank you. All right, anything, you still have some time left, Mr. Page. It's 10:55. You normally would, your full 55 minutes would end at 11:19, so about 20 minutes left in your argument. Thank you, Mom.
One moment here. Just, I did want to clarify the record. I reviewed the email from Gorley, and Gage's grades in 5th grade was .088. That was in Las Vegas. Now he had, in 6th grade in Washington, 1.250, and last year was 1.479 GPA. So it speaks for itself, but the trend is upward.
Okay. Do you want anything else you wanted to add?
No, I didn't have anything else I wanted to add.
Okay, so that would bring you to 42 minutes, Helen. You can type that in there if I did the math correctly. All right. So with that, then Dad gets a full 10 minutes uninterrupted of rebuttal, and then we would convene. I think I'm going to write not trial decision. I think I'm going to write the decision and have it out, what's today, Friday? If I can get it done by the end of the day, then I will get it in your email by the end of the day. Okay, I just have to look up some of the case law, the factors, and then put findings, but these are just a temporary order. But like I said, I don't want it to set the tone for the trial. But I want to address just the temporary issues. Okay. Mr. Counsel, Helen will have you in, and you have a...
Can we take 5 minutes for a restroom break, and I'm trying to locate a photo?
We have a break.
Okay. That's fine. 5 minutes.
There's a restroom.
11:02. 11:02. Helen, we're off. Thank you.
Thank you.